What if there are liens on the house?
Junior liens? Like,
yeah.
Other than the first and
Yep.
second mortgage, for example?
Yeah, like credit card liens.
Well, in a short sale scenario, so we got the note and the mortgage, right? Well, I also gotta take care of these. Does that make sense?
I'm going to ask a question to you, but I'm going to look at someone else when I ask the question.
Okay.
If it's a low-end property with all this messy stuff going on, what would you do?
That was our next question, exactly.
If it's a low-end property?
Yeah, if the property might be lucky to sell for 90 and they owe 178 on their mortgage, just saying, just, you know, random numbers, and say they've got about 10,000 in junior liens, maybe 15.
What kind? Do you know what kind of
credit card?
Credit card? Do they live there?
Mm-hmm.
They live there now?
Mm-hmm.
What I would recommend is that they file for a declaration of homestead.
They already have homestead.
Tax homestead, right?
Right.
Different animal.
Okay. Like declaration of domicile, is that the?
It's a declaration of homestead. So what you do is you file a declaration or notice of homestead with the clerk of court. It's a great tool if you can use it. Everybody's been to realtor school. What does that mean? If I notify my creditors of the fact that the property I'm talking about in my notice is my homestead. What does that mean? It's off limits. It's off limits, right? To everybody except for purchase money creditors. Right? So here's your first mortgage of 178. Here's your junior liens. After 45 days and no counterclaim or no challenge by the junior lien holder, bye-bye. From a title insurance perspective, that's all we need to have.
Does the clerk remove them? Or?
They're removed
by magic.
By operation of law. By operation of law is the technical term. So
do anything? It's been 45 days here before.
No, all you have to do. So give us a call and we'll draft a notice of homestead for you. You take it down to the clerk or you file it with the clerk's office. The clerk will send out notices to these particular creditors by mail, and they have 45 days in which to challenge the declaration of homestead. If they don't challenge it, from a title perspective, I'm good to go.
Yeah, what's the challenge?
Well, I mean, what are they going to challenge? The fact that they
it's
live
not
in
homestead?
Yeah, they would have to proactively bring a defense to the notice that said, "Oh, that's not their homestead because of A, B, and C." Well, what's the like?
If it's debts they racked up prior to purchase.
Doesn't matter.
Okay.
If any junior lien
So they gotta
that's not purchase money, as long as it's not purchase money.
So Chris, that's different than homestead, so it's something that any homesteader has to physically do.
If they want to accomplish what she's asking. Yeah.
And you can only do that through an attorney, or?
Not necessarily. You can do it on your own.
And it's called filing a tax declaration.
But we don't want to do that.
No, we don't.
I mean, it's called a notice of homestead. It's basically a one-page form that says, I, debtor, hereby notify creditor the fact that the following property is my constitutional homestead.
I've seen things like that in the paper. Is that what?
Maybe. Could be.
Yeah.
Yeah. But what I'm saying is they will proactively mail the notice to the creditor.
Okay.
The clerk does.
The clerk does.
If they have a lien on the property.
Yeah.